mentioned. The women's liberation movement in the U.S. and a few other developed countries succeeded in forcing the UN to hold several international conferences on women. These conferences proposed recommendations which resulted in the adoption by the UN of various women's rights declarations, including a declaration on the elimination of violence against women in 1993. These declarations called for the adoption of national laws against domestic violence, but they bring in the social science because they also ask for funding for the WHO studies about the prevalence of domestic violence. And then that's all then part of a historical and sociological process that's working together that eventually leads to defining domestic violence as a violation of human rights. On the whole, the WHO evidence lends credence to the view that prevailing risk factors related to the high incidence of domestic violence are more common in the past, and therefore the further back one goes in history, the greater the prevalence of domestic violence. But a fluctuating trend, rather than a straight line, is suggested by case studies, some by historians, some by anthropologists, that suggest that domestic violence is also related to large-scale social stress factors, such as demobilization of soldiers at the end of a war, male unemployment, male underemployment, indeed catastrophic shifts in the opportunities for men to fulfill the male role. On the whole, historians tend to emphasize that domestic violence predated the arrival of European colonizers. However, they also detect specific ways that imperialism did increase the level of domestic violence. For example, historians of sub-Saharan Africa and scholars studying hunter-gathering groups argue that prior to colonialism, relations of men and women did not include much display of overt aggression by men against women. Many ethnographers describe the peaceful relations between men and women among the San of South Africa. That is, they're usually called the Bushmen. Armed during the war in Namibia and undergoing wrenching changes in gender roles from hunter-gatherer to farmers and housewives, women were changing, but men found that they were unable to fulfill their provider role. And as a result, one sees a great deal of drunkenness and rage being expressed among what were once thought of as the very gentle San, and they became quite violent. Probably the greatest difficulty in creating a comparative history of domestic violence is that the term domestic violence, virtually every other key term related to the topic is contested and subject to change. The term domestic violence was a creation of the 1970s. Subsequent political coalitions have preferred terms such as gender-based violence, which includes a broader range of abuse or intimate partner violence, to recognize that domestic violence is actually more common among common law or cohabiting couples, and is found among couples who don't live together at all, and prevails as well among same-sex couples who do live together. The contemporary definition of gender violence will often include dowry deaths, female genital mutilation, acid attacks. On the whole, gender violence includes rape, marital and otherwise, as well as domestic violence, and thus opens the way to many investigations of rape during war and conflicts so tragically evident in Bosnia, Rwanda, South Africa, Liberia, and the Congo. In many cultures, historians have included within the domain of domestic violence verbal abuse because it was often a specific and separate crime. Marital rape is included in virtually all definitions, was mentioned in many divorce suits, but was excluded until very recent time in terms of its definition of a crime. The domestic in domestic violence has to do with the notion that this topic involves family relations. The farther back one goes in history, the more likely that the domestic will include households peopled by foster children, apprentices, servants, boarders. nor is the related assumption of co-residence in the definition of household always the case, not merely because of the separation of a couple or distinctive living rules in kinship, but because of migration. Scholars of African history have been keen to include co-wives in their definition of the domestic, and Africanists and students of India have also insisted on a household expansive enough to include considerable abuse directed by in-laws. Domestic violence these days is usually defined as a crime, and the definition of a crime and the way it is punished in turn is related to a legal system. World legal systems can be conveniently divided between the informal or customary and the formal, the verbal and the written, the civil and the criminal, the religious and the secular, with the recognition that many are in fact hybrids of these categories. The impact of European imperialism on prior legal and religious systems of law becomes an important topic with the globalization of the history of domestic violence. If anything, the world history of domestic violence has strengthened a term that has gone into some disuse within European and U.S. women's history, namely patriarchy. It is useful to invoke here the idea of Sylvia Walby that there are different patriarchal structures. We might call them subtopics, interacting variables like a mode of production, paid work, the state, violence itself, sexuality, culture. Judith Bennett's defense of the history of gender as the history of patriarchy in History Matters makes the following points: that a grand theory of patriarchy is not a goal and not likely to be forthcoming, but instead, here's her quotation, "Our job is to understand the many varieties of patriarchy that have so successfully supported its adaptations to so many different historical circumstances." The key feature of patriarchy in relation to domestic violence is the unequal power relations of men and women, both in the larger culture and within the marital relation. Unequal power relations were evident in the sexual and property rights accorded husbands, the sexual double standard, the restrictions on women's independence and freedom of movement, husbands' expectations and demands for the obedience of wives and children, husbands' demands for sexual intercourse and fidelity. Denise Candiati describes another important aspect of unequal power relations, the patriarchal bargain, which refers to the agency and participation of women in supporting and maintaining patriarchy. She portrays women not simply as victims, but as agents in the oppression of other women. One of the strongest pieces of evidence supporting her view is the social surveys that I cited that went along with at the same time as the WHO studies. And those social surveys show that women in the set of countries that they studied, for example, Ethiopia, Mali, Uganda, et cetera, women are more accepting of wife beating than men. World history is also the history of world religions, separate intellectual traditions, but traditions in contact with each other. The comparative intellectual and religious history of domestic violence describes a dominant and oppositional, as well as oppositional traditions in Islam, Christianity, Judaism, male authorities positing a husband's right to chastisement of a wife, and authorities who oppose that view wholeheartedly or with modifications. I have to add as a parenthesis, I have not found any oppositional culture in Confucianism itself. But of the world's major religions, the issue of wife beating and Islam attracts the greatest attention because the statement in favor of wife beating was made in the holy text, the Quran, rather than by religious authorities. It's 4.33 of the Quran. It reads, "Men shall have the preeminence over women, but those whose perverseness ye shall be apprehensive of rebuke. and removed them into separate apartments and chastised them. Al-Tabari, he died 923 Common Era, is seen as representative of early interpreters of this passage in claiming that wife beating should be used but as a last resort. The international history of domestic violence also confirms a previous finding of the research that battered women employed a variety of strategies of resistance, from talking back to running away to engaging in adultery to fighting back physically against the blows that they received. Outside of complaining to religious authorities, neighbors, or family members, one escape route for battered women was running away. Accordingly, husbands often resorted to various ways to disown the wife's debt or force her to return. Because France had increased access to divorce, the French in Sudan in the 20th century legalized divorce, but were not prepared for the consequences of women fleeing their marriages and moving to cities. In fact, sending fleeing battered wives to prison was their modern response to the situation. Under customary law, a fleeing wife had usually been punished with several switches of a rope. In 19th century Egypt or Tunisia, disobedient wives could be sent to special prisons where they could learn obedience before being returned to their husbands. Such prisons exist still today in Afghanistan. In many regions of the world, people who harbored the runaway wife were also punished. Neighbors or relatives could intervene on either side. Historians of Europe trace a transition from public shaming of the scold, the woman who beat her husband, to public shaming of the wife beater. And there were these parades in towns where this public shaming went on. The naming of these parades was charivaris in Europe. In North America, they were called chivaris. And they were replete with horns, banging pots and pans. More common than such parades outside of Europe and North America were simply groups of women who arrived at the home of a husband's mistress and pummeled her. The major legal escape route for marriage, sometimes after or as a result of running away, was the separation of divorce. The long arm of history moves from control of separations by religious authorities to divorce, with divorce becoming more accessible, more common. Yet throughout most of world history, the number of separations and divorces was relatively small and in general required money and time to pursue. Invariably, religious and judicial authorities urged reconciliation. Legal systems varied greatly as to whether subjection to violence was sufficient reason in of itself to grant dissolution of a marriage. Bianca Primo's ingenious reading of petitions of women in colonial Spain suggests it's possible to learn about the verbal complaints of abused women who never pursued a legal case. Runaway wives or their male relatives could complain to a priest or a local judge. For the most part, however, these complaints also led to reconciliation of a husband and wife. Catherine Burns, who studies colonial Chile, examines the ways a stock clause in a notarized contract allowed an abused woman to assert into the written record her story of a husband's abuse. And according to a Spanish contract law, a contract was not valid if the consent was forced. So, but thinking about this a little bit more, a woman's statement that her husband had threatened to kill her in such a contract suggests also that she might have wanted her relatives to know of her abuse in the event of her death. There's no simple answer to whether the new legal systems created by imperialism helped battered women or hurt them. There were many empires, many systems of law, and the systems of law that were created had much more impact on other areas of the family than domestic violence. In general, the indirect rule of the major European powers, say French, Italian, English, did not so much supplant this system of pre-colonial governance as bifurcated in what has been referred to as legal pluralism. We know less about what has been called customary law in India than about the judicial decisions of British judges, who seem to have governed according to their own version of what they thought was supposed to go on in the island nation. Customary or Sharia law handled domestic violence if it arose between a Muslim husband and wife, or a customary law, Hindu husband and wife. But there are also many native women who were the wives or live-in partners of Englishmen. And what we find here is that these kinds of cases were dealt with by British judges. And the cases that came to the courts mainly involved lower-class Englishmen, often living with native women, and who could be punished for domestic assault. But generally, they were punished lightly, according to the basic principle that only the most excessive forms of marking, maiming, wounding deserve to be punished. In most places and times, domestic violence was not a crime. In fact, it was not only not a crime, but it was instead a right of the husband, a disciplinary right of chastisement or right of correction. Sometimes this right was explicitly limited to moderate chastisement. Other times the right was implied. Judges, legal authorities, and the general public offered varying claims about what was excessive correction and thus a crime under the crime of assault. Now we get to the category of crime. The dividing line between the civil and criminal law in so many of these cultures and histories was not hard and fast. I want to instead make the distinction between complaints of abuse brought by women and their relatives and complaints of abuse that, when we're talking about a crime, that were not initiated by them but by the authorities. Usually these two kinds of complaints are called private disputes versus public disputes, but the terms may be more confusing than helpful. These first kind, the complaints brought by women and her relatives, were designed to produce some kind of what we would call order of protection. In these, a woman's credibility before an authority depended on her reputation and or the standing of her family. And in these kind of cases, the husband or the family were then required to post a peace bond, and then if the bond was violated, then there could be fines or imprisonment. In this kind of dispute, there was no clear standard for what amount of violence had to occur for a judge to order such a bond. Sometimes the pursuit of this peace bond could be a difficult and even costly process, but yet it is the kind of first layer that eventually will disappear or become much less common in the general history of the criminal law. And then we get to the second category, which are I use the phrase